This morning, subject to court approval, the Department of Justice is announcing a global resolution of our criminal and civil investigations into the opioid manufacturer Purdue Pharma, as well as a civil resolution with members of the Sackler family who comprise shareholders of the company. Before we address the specific terms, I want to provide some context of how today's announcement fits into DOJ's wider efforts to address the opioids crisis. DOJ obviously has many longstanding and ongoing drug enforcement activities. But during this administration, we have augmented those with a series of new initiatives targeted at both illicit opioids, like heroin or synthetic fentanyl, and we've targeted the diversion and abuse of prescription opioids as well. These are shown on the chart we have today. This one over here, where we show J-code and Operation SOS on the illicit side of things, and we show the PIL task force, the Prescription and Interdiction Litigation Task Force, ARPO, OFIDU, and healthcare fraud strike forces, all on the prescription side. And by all of these efforts, we have targeted unlawful activity involving opioids at every level of the supply chains. There's very different supply chains on the illicit side and on the prescription side. On the prescription side, this means unlawful actions by manufacturers, distributors, pharmacy dispensers, or physician prescribers, for example. So today's announcement involves one of the most important participants in the supply chain of prescription opioids at the manufacturer level, and a resolution which, if approved by the court, will redress past wrongs and will also provide extraordinary new resources for the treatment and care of those affected by opioids addiction. The global settlement announced today involves the company pleading guilty to 3 felony counts for defrauding the United States and violating the anti-kickback statute from 2009 to 2017. In addition to the company having agreed to plead guilty to these 3 felony counts, the company has agreed to a $3.544 billion criminal fine and a $2 billion criminal forfeiture amount. Further, on top of those, to resolve its civil liability, Purdue Pharma has agreed to $2.8 billion in damages to the United States. Now, the company's in bankruptcy, so the corporate resolution is subject to the bankruptcy court's approval. If it's approved, this will be a corporate settlement in total of more than $8.3 billion. Additionally, members of the Sackler family have agreed to pay $225 million in a civil settlement that will provide civil releases only. It's also important to note that this resolution does not prohibit future criminal or civil penalties against Purdue Pharma's executives or employees. Now, this resolution must be understood against 2 larger contexts. First, the company's bankruptcy, and second, as I've referenced, the Department of Justice's overarching work addressing the opioids crisis. We'll take the first one first, the bankruptcy. The company's bankruptcy in the Southern District of New York involves many creditors, from some private creditors to federal, state, government, and local creditors. In general, the creditors are aiming to ensure that nearly all of the proceeds of the bankruptcy go to opioid abatement programs, and the Department of Justice generally supports that goal. Towards that end, a key piece of today's resolution is based on the future of the company that was Purdue Pharma. The agreed resolution, if approved by the court, will require that the company be dissolved and no longer exist in its present form. It would require that the Sacklers must relinquish all ownership and control of the company or of any of its successors, and the company's assets would be transferred to a new public benefit company, or PBC, owned by a trust for the benefit of the American public. The PBC would be charged with providing its medicines in a manner as safe and possible, without diversions, while providing millions of doses of medicines to treat opioids addiction and to reverse overdoses, and otherwise taking into account long-term public health interests. And again, to be clear, the Sackler family will have no role in creating or controlling the new PBC. If the bankruptcy court approves this, the department will credit the company for the value conferred through the PBC against the criminal forfeiture amount, except for $225 million that will be paid to the United States on the bankruptcy effective date. The criminal fines and civil damages would not be affected by this. This global resolution builds on the department's other recent opioid successes. Just as the department prosecutes illicit drug traffickers, the department's been committed to doing the same with respect to the abuse and diversion of prescription opioids. We've prosecuted medical professionals who've contributed to overdose deaths, or run pill mills, or defrauded the government's healthcare programs. We've prosecuted opioid distributors, including McKesson, Miami Lucan, and Rochester Drug Cooperative. We've reached substantial settlement resolutions with other manufacturers, such as RB Group and Indivior, as one example, which was, if I recall, in the neighborhood of $2 billion, as well as another manufacturer, Insys. These are all examples of the department's unwavering commitment to turn the tide of the opioid crisis that's ravaged the country. Today's announcement focuses on the problems from wrongful activities in the prescription opioids realm, so let me note that our efforts there appear to be making a difference. The CDC reports that since 2017, prescription opioid overdose deaths have decreased by more than 18% in the first 2 years. And there has been a 47% decline in prescription opioids being dispensed. But we will continue all of our efforts, including building on the record of more than 8,000 opioids prosecutions in 2019. And not only through enforcement. For example, the Department's Office of Justice Programs awarded grants totaling more than $341 million to help fight the addiction crisis looming over the United States. Let me also say today's announcement is very much a success story in the close coordination between the U.S. Attorney's offices in New Jersey, the U.S. Attorney's Office in Vermont, the Civil Division's Consumer Protection Branch and its Civil Fraud Section, and I also want to thank the important contributions of law enforcement, including the FBI, the DEA, and the Health and Human Services Office of Inspector General, all of whom would normally be here with us, but because of the pandemic, we've limited the number of people on the stage today. So I want to thank this entire team for their relentless work in bringing about this investigation and bringing it to a successful resolution. Today's announcement is also particularly timely, given that October is National Substance Abuse Prevention Month, and just a few days from now, on October 24th, is DEA's National Prescription Drug Take Back Day, which allows for a safe, convenient, and responsible means for disposing of unneeded prescription drugs that are sitting in medicine cabinets at homes. Keeping the American people safe is the department's highest priority. And as today's announcement reaffirms, the department will not relent in our efforts to combat the opioids problem.